Hello all. Today I'll be presenting a case of Mrs. Field versus Eli Lilly and Company. This case was decided on July 20th, 2015 in Alabama District Court. In my opinion, this case perfectly illustrates an example of how a failure to warn on a label claim can cause big woes to pharma company. And that's what exactly happened in this case. Mrs. Field alleged Eli Lilly and Company that due to her ingestion of Prozac during pregnancy, caused her son to be born with congenital heart defect. And had there been better warnings on the label, prescriber wouldn't have prescribed this medicine. On the other hand, defendants argue that she fails to establish a genuine dispute of material fact as she lacked prescriber's testimony, who died 4 years prior to the commencement of this case. And moreover, she also lacked any physical evidence like prescription records, insurance record to prove that she actually took Prozac during pregnancy. But uh, in spite of lacking the physical evidence, she managed to survive the summary judgment on the basis of a note which was provided by the doctor at that time, which suggested that he was considering prescribing this medication. Later on in the case, defendants also argue that under Alabama's laws of learned intermediary, uh, plaintiff must prove that had there been stronger warning on the label, a prescriber wouldn't have prescribed this medication. And this testimony must come from doctor himself. After reviewing this motion, a court denied the motion and believed that Mrs. Field can still prove that the outcome would have been different in case of stronger warning. And plaintiff actually successfully manages to prove that with the help of nurse testimony. Doctor's nurse, which used to work with the doctor at that time, she testified that doctor was regularly in a habit to discuss the label warnings with the patients, and had there been stronger warnings, it would have been discussed with the patients and the outcome would have been different. So to sum up the case, uh, court believed that plaintiff has raised a genuine dispute of material fact, and under Alabama law of learned intermediary, which states that manufacturer fulfill his duty to warn the learned intermediary by giving them full information, which in this case manufacturer fails to do that, and that's why summary judgment was in the favor of plaintiff, and the case summary judgment was in the favor of plaintiff.